will get started. Welcome again to the Options for Couples webinar. We wanted to do this right before the most romantic holiday of the year as you're considering what you and your partner might want to do next steps in your immigration journey. So my name is Catherine Del Rosario. This is my colleague, Natalia Blauvelt. We are attorneys at McEntee Law Group. We are based in Chicago, and we focus exclusively on immigration law, a mixture of family-based, employment-based, removal defense, and humanitarian immigration. But this particular webinar is going to focus on these family-based options. Just as a reminder, this presentation is for general purposes only. Do not consider it to be legal advice. You'll want to contact an attorney or an accredited representative for individual advice about your case. So we are lawyers, but we are not your lawyers. So again, you'll just want to take this as general information. And all the timelines that we're going to reference are estimates as of the date of this presentation. It's February 2025. They're subject to change depending on the government's workload and the specific facts of your case. This is a roadmap of what we'll be covering today. So we're going to be comparing two major options, the K-1 fiancé visa versus the marriage-based visa process. So we'll tackle the K-1 first and then move to the marriage-based. During both options, we'll talk about how to prove that a relationship is bona fide, like what all goes into that. What are the requirements for financial sponsorship? What happens during the interview? And then we'll reserve time at the end to answer any questions that you might have. So through Zoom, there's a Q&A feature. Please put your your questions into that box, the Q&A box specifically, and we will make sure to address those. Okay, and then just to start, we wanted to go over some basic definitions, which seem like common sense, but immigration has very specific definitions of what these terms mean. So when we say fiance, we mean a couple that's engaged, but not legally married anywhere. So they are legally free to marry, whereas a spouse is legally wedded, and a common law marriage may count for purposes of this, depending on the laws of the country where the common law marriage took place. When we say petitioner, we're talking about the U.S. citizen, this should say U.S. citizen fiance or the U.S. citizen or green card holding spouse. And then beneficiary is the foreign national fiance or spouse, depending on which process we're talking about. And then a child is considered an unmarried and under 21 years old. So I'm going to hand it off to Natalia to start us with the K-1 option.
Thank you, Catherine. All right, so we are going to start with the K-1 option. First of all, just to let you know what this process is, I'm going to tell you who it was designed for, what it generally allows to do in the US. So this whole process was designed for people who are not yet married, but they are engaged. So there should be an intent to marry in the US, and this intent should be proven to the US, to the Department of State and to the US CIS. So when people, the couple comes to the US and the foreign national comes to the US on a K-1 visa, there is a requirement to get married within the first 90 days of arrival in the US. This kind of visa by itself does not provide for a green card, but when a person arrives in the US, he or she will have an ability to obtain a green card to live and work in the United States. So that's kind of a second part of this entire process. And it becomes available when person is already in the US on the K-1 visa. There are some very strict requirements to this process. So one, and the first and the most important requirement is that the petitioner in the process should be a US citizen. So lawful permanent resident will not be able to complete this process, unfortunately. A U.S. citizen is someone who is either born in the U.S., someone who naturalized in the U.S., or someone who obtained a certificate of citizenship. It's a derivative citizenship. The petitioner and the beneficiary should be free to marry, and some countries like Bulgaria or, for example, the Philippines, they have a requirement to provide certain kind of paperwork to show that the beneficiary is free to marry. The petitioner does not have to show that he is free to marry by providing a certain, certificate saying so. But if the petitioner was married previously, then a divorce certificate will be required for the process. The petitioner and beneficiary have to meet in person within the past 2 years, so the 2 years preceding the filing of the petition. There are certain exceptions that apply. If this meeting in person requirement is impossible to meet for religious, cultural, social reasons, then you may argue that. Sometimes you may argue that there was, some kind of an extreme hardship to the petitioner to meet in person. So it can be medical hardship, it may be financial hardship, but either way, that has to be proved. Criteria for the K-1 visa also specifically outlined in the regulations. So first of all, you will have to prove the bona fide nature of your relationship and intent to marry. First of all, to prove the bona fide nature of relationship, obviously you will need to provide certain kinds of paperwork. We call it bona fide evidence. Your intent to marry can be proven by providing letters of intent to marry. And as attorneys, we will draft those letters for the petitioner and the beneficiary in this process. The petitioner, who is a US citizen, needs to meet certain income requirements. So for the K-1 process, that income should equal at least 100% of the federal poverty guidelines. If you go to the USCIS's website, you will be able to see a schedule that they post in there every year, and they update it in accordance with the poverty guidelines posted by the US government. So this requirement actually may be beneficial for a lot of people because it's a lower amount of income that the person has to show in order to sponsor, as opposed to a marriage-based case. We'll talk about it in more detail. Petitioner's criminal record matters. So if the petitioner was ever convicted, accused of child abuse, neglect, stalking, domestic violence, sexual abuse, that petitioner will be barred from filing a K-1 petition. So if that's the case, in your matter, I would strongly recommend to talk to an immigration attorney to see if there are any options to go around that requirement, potentially by filing a waiver of the Adam Walsh Act bar.
And just noting that the purpose of that act is really to protect the foreign national. That's why it's these certain types of crimes that might appear, in the context of a couple, that's why these are the relevant ones.
And even though it's just those specific crimes that are relevant in this process, the USCIS will ask the petitioner to provide certified statements of dispositions regarding every single conviction. So definitely review the criminal history of the petitioner to see what kind of additional requirements would apply in regard to that process. The procedure itself starts with the petitioner filing Form I-129F with the USCIS. It's a petition that can only be filed by a US citizen. The filing fee for that petition is $675. The petition has to be accompanied by supporting documents. We call it bona fide documents and the personal documents. All of that has to be put together in one package because the petition will be reviewed by the USCIS, and the USCIS will have to refer to the supporting documents in order to adjudicate that petition. If the petition gets approved, it will be valid for only 4 months, and the case will be sent to the National Visa Center. The petition will be valid for 4 months, but there is an option to extend the validity period of that petition. The extension process is discretionary, and you can file for that extension with the consulate that will be handling the case. So when the case is already at the National Visa Center in the US, that means that the National Visa Center will prepare the case to go to the consulate. At the NVC stage, you will need to file Form DS-160 and pay the filing fee, which is currently $265. Also, at that stage, you would need to submit Form I-134, Affidavit of Support, so that comes from the petitioner. The beneficiary will need to obtain police reports from every country in which the beneficiary resided after age of 16 for more than 6 months, or from every country in which the beneficiary was arrested, convicted, or charged with an offense. And like I mentioned previously, the petitioner would need to provide certified statements of dispositions for every single offense that the petitioner committed in the past. The beneficiary will also obtain a medical exam report. So that's a medical document that is prepared by a civil surgeon, a special doctor designated by the Department of Homeland Security to complete this kind of reports. This is something that an attorney cannot help you complete. So you will go to a designated civil surgeon who will examine you as a doctor, will take a look at all the records, medical records that you will bring. Maybe you will run certain tests depending on your age and the CDC requirements related to the medical conditions and vaccinations. It's important to know that as of January of 2025, the COVID vaccine is no longer a requirement. It is no longer required for this process, not even a single dose. All right, so this is the timeline for the K-1 fiancé visa process, and this is the very first part of the whole process. So that's not the end of the process. So first of all, you file the K-1 petition that goes to the USCIS by the petitioner. Then the USCIS adjudicates that K-1 petition that normally takes from 12 to 15 months. Although in 2024, we had some of the petitions adjudicated within 5 months. I wouldn't count on such fast processing timelines in 2025 because we have the new president and the new administration that is cutting the number of federal employees, including the USCIS employees. So there will be some delays, potentially, at least our firm expects to see some delays in this process. So once the K-1 petition is approved, it goes to the National Visa Center, and it really depends on the beneficiary and the petitioner on how fast you can complete this process. It normally takes from 1 to 2 months, but it can take longer if there are some delays with the documents and supporting evidence. Once everything is submitted to the NVC, the case will get in line for an interview at a consulate outside of the United States. At that point, we prepare for the interview. We will definitely assist with an interview package as an attorney. So we will also have a prep session with the beneficiary, so the beneficiary feels more comfortable during the interview if we are to represent the beneficiary at the for the interview. We cannot represent the beneficiary at the interview because it's outside of the US, and the Department of State has certain, restrictions as to who can attend the interview. The interview scheduling takes time. And I would say it takes anywhere from 6 to 12 weeks, and sometimes it may take longer. It depends on an embassy that is processing the case. To give you a couple of examples, the U.S. Embassy in Bulgaria was able to process the case very quickly within a couple of months, while the U.S. Embassy in Mexico may take a year or even longer to process this kind of petitions. Same goes to the U.S. Embassy in Abu Dhabi, which is extremely overwhelmed, and as of now, it's reviewing documents that were submitted in 2022, and we are in 2025. Once the K visa stamp is issued by the consulate, it will take about 2-3 weeks. The passport will be delivered to the beneficiary for the beneficiary to use that passport to enter the US during the validity period of the visa. So pay attention to the validity period. It's usually 5-6 months. Once the visa expires, the beneficiary cannot enter the US on an expired visa, and certain actions will have to be taken with the consulate to renew the visa, or the whole new process all over again may be required for that matter. So pay attention to the validity period of the visa itself. All right, so let's talk about considerations in regard to the K-1 visa. There are pros and cons, obviously, like in every other immigration process. So what are the cons in this process is that you don't have to be married to actually start the process. So you can be just engaged, and your marriage plans can still be in the making. You will have to get married in the US, and you can definitely plan your marriage date, within the first 90 days. The affidavit of support that the petitioner will need to submit in this case is a simplified version of an affidavit of support. It's Form I-134. You don't have to submit Form I-864, which is a general affidavit of support, and it's a more complex form, and it's an actual contract between the petitioner and the US government that is enforceable in courts. As opposed to that general affidavit of support, you will need to provide a simplified affidavit of support, which is Form I-134. It has not been legally enforceable in court as of now. We cannot speak for the future, but normally we are, pretty confident saying that it's not really legally enforceable, but still, it may be enforced legally in the future, but it hasn't been the case thus far. The wedding timeline is uncertain, and for some people that can be a negative, point in the whole process. Also, no international travel will be allowed once the person is in the US, unless the person gets an advance parole or a green card to travel internationally. A K-1 visitor who comes to the US but hasn't yet received a work authorization cannot work in the US. So keep that in mind. The K-1 visa does not provide for a work authorization or travel benefits. Also, there is no joint sponsors option for the affidavit of support Form I-134, but the income requirement is much lower and easier to meet. The K-1 green card process is the second step of the whole K-1 process, and that step is to be completed in the US. So once the K-1 beneficiary comes to the US, there is a requirement to get married within the first 90 days. And also there is a requirement to file for a green card within the US if the person wants to get a green card. So the US citizen will need to sponsor the K-1 spouse who is physically inside of the United States by filing the general affidavit of support. So that's the second affidavit of support that will have to be filed in the case once the person is inside of the US. Same end goal exists here, to live and to work permanently in the United States. So what this second part entails is the filing of Form I-485 with a medical exam report and supporting documents. You may also file an application for an advance parole. and for work authorization. The filing fees will be $2,330. A civil surgeon will charge separately. The fee that they charge usually ranges, I would say, from $250 to $500, depending on where you live in the United States. In Chicago, roughly, I would say it's around $300. You also will need to provide evidence of marriage within the first 90 days. It's a marriage certificate that serves as evidence of marriage in the US. And additional evidence of bona fide marriage will be required. So you will need to continue taking pictures, maybe, acquire some financial evidence, residential evidence to support your green card case within the US. And here is the timeline that will help, kind of to visualize the steps involved in the second part of the process when we're talking about the green card. So it starts obviously with the green card being prepared and filed. Once we file the case, we will receive receipt notices from the USCIS. Those normally comes within 4 to 6 weeks from the date of filing. You cannot file Form I-485 online, so you'll have to file it on paper. And when you file on paper, it takes longer to get the receipt notices. The foreign national will attend a biometrics appointment here in the US, and it usually gets scheduled within 4 to 6 weeks from the date of filing of the green card case. Work and travel permits will be adjudicated by the USCIS, and processing times really vary because the USCIS may be overwhelmed with, this application at a time when you filed, or the USCIS may take additional time for the FBI checks, let's say for the travel document. An employment authorization document is normally issued within, I would say, from 4 to 8 months, and the travel document takes longer. Sometimes it comes in pretty quickly, and sometimes it doesn't come at all. There are options to expedite the adjudication of those documents, but it's also very discretionary, and you'll have to meet certain requirements for the expedite process. The next step in this process is the adjustment of status, so the actual green card interview in the US. With the new administration, we learned that it's the goal to interview every adjustment of status applicant. Previously, the USCIS would waive interviews if it had a lot of evidence on file and it believed the applicants. However, things changed with this administration, and we expect every single case to be scheduled for an interview. So the interview will be attended by both the petitioner and the beneficiary. And the green card, depending on the results of the interview, if the results are positive, then the green card will arrive within 1-2 months after the interview. And if there is a denial of the case, you will have a chance to talk to your immigration attorney about the case that was denied, if it was denied in error. And that's a whole different topic. We will do a webinar on it separately. So that's how the timeline looks. How do you prove a bona fide marriage? So that's a very good question. So first of all, what's the requirement in the regulations? The regulations that we have in place require the petitioner and the applicant to prove that at the time of the marriage, there was an intent to build a life together as a married couple. It's called a good faith requirement. What it entails is that the beneficiary and the petitioner prove that they lived together, shared finances and experiences in life. So shared residence can be proven by providing mortgage statements, lease agreements, IDs, driver's licenses, utility bills, some correspondence. You can really be creative in terms of evidence. At McEntee, we have a list of evidence items, and you can just kind of, our clients can go through the list and see what applies to them, what doesn't. Combined finances or commingling finances can be proven by jointly filed tax returns. If those are not available for people who just got married, you may provide joint bank statements, joint insurance coverage, health, life, home, auto insurance policies, mentioning you as either holder or the beneficiary of that policy. If you own property, and it can be, home, rental property, vehicles, you can provide proof of that as well, and you also can be creative in terms of that evidence. If you don't have a lot of financial and residential evidence, you can prove shared experiences of you as a married couple. You can provide photographs. If you booked hotels together, you can also provide, proof of the bookings. You can provide evidence of the proposal and wedding, maybe some contracts with a wedding venue or a photographer. So all of that evidence also counts. If you traveled together or attended certain events together, then make sure to take pictures and also have evidence of that. Affidavits from friends and family matter. If they are US citizens or green card holders, then they should be absolutely, free to provide those affidavits, because if they have, any other immigration status, I would, think twice before providing affidavits proving the relationship. So how does the USCIS determine if there are red flags on the application? So there are certain red flags that, we know about based on the BIA decisions, based on how the USCIS processes cases. So first of all, it's age difference. And here we're talking about a gap, in age between the beneficiary and the petitioner. So if it's more than 20 years, that may be concerning, maybe not. It also depends how, similar people are. So if there's a difference in language, religion, cultural background, that may be considered a red flag as well. If there's no shared residence, that's a huge red flag. The USCIS expects people to live together, but that may not be the case in your specific case because of the circumstances of your life. So we have argued that, in some cases when people did not live together, the petitioner and beneficiary were successful arguing that they're still married with an intent to live this life together. If not much time has passed since, the engagement, that may be a red flag as well. If there were some previous petitions, immigration petitions, then that may be considered as a red flag as well. Financial sponsorship. So now we are talking about the financial sponsorship for the green card process. So for the green card process, sponsor must earn at least 125% of the federal poverty guidelines, and that will be determined by the household size. We mentioned 100% of the federal poverty line here, but it's actually 125% for the green card process, the second step within the US. The eligibility for financial sponsorship is based on sponsors' last 3 years of tax returns. So we look at the total income line, but the most recent tax return is the most important tax return for our purposes. There was an option not to provide all 3 years of tax returns, but that's not an option anymore. You'll have to provide all 3 years of tax returns. If some years you just did not earn enough and did not file a tax return, you may just say that in addition, in an additional affidavit and provide that affidavit to the USCIS, just kind of explaining why you have not filed taxes. But your most recent tax return should definitely be on file. If the petitioner does not meet the financial requirements, then definitely consider a joint sponsor. So it can be a US citizen or a lawful permanent resident who meets the income requirement. We also will need to look at the household size of that joint sponsor. What considerations you should keep in mind for the K-1 green card process? So first of all, You may file for a green card as the beneficiary in this process only after you get married, not before. You would need to stay in the United States while your green card is pending. So if you leave without having a travel document, then unfortunately, that would mean that the application will be considered abandoned by the USCIS. No international travel without an advance parole or a green card will be allowed. And as a beneficiary, you must maintain residence in the US once you get your green card. You will be required to file tax returns in the US. If your CPA tells you to do that, you generally will need to maintain residence in the US and spend at least half of the time within a year in the US. There is an interview process, and like I mentioned previously, in 2023 and 2024, a lot of interviews for our clients were waived by the USCIS. The interviews will likely not be waived moving forward. So what you should keep in mind is that you should present your supporting documents at the time of the interview. You may have more documents at the time of the interview as opposed to how many documents you had at the time of the filing. You definitely need to review the case because the USCIS officer will review the case as well. And if you have any changes, let the USCIS know about them. You will need to present your story. So talk about your relationship. And this is the part where you can be, emotional, you can show connection to each other, you can show love and support, and that all matters. All of that will be done under oath. So whatever you say at the time of the interview will be under oath. That means that you'll have to be telling the truth and nothing but the truth. All
Okay.
right, so we are moving to the second part of this webinar, which is an immigrant visa. Catherine, I'll let you handle this.
Thank you. We will come back to some of the points that Natalia touched on because they are relevant in this process too. But the basically now we're moving to the marriage-based option where the couple is legally married, and there are kind of two ways to go about it. The first one is the immigrant visa route. So this is when the US citizen or we say LPR, that means lawful permanent resident, so the green card holder sponsors the spouse who is living in another country. And so the application for the immigrant visa, which actually leads to the green card, that's going to happen outside the United States. But the end goal is the same. It's to live and work permanently in the United States. This is the timeline, briefly, for what this process looks like. The I-130, which is a family petition showing that you are a couple, gets filed with the USCIS here in the States. They will review it. It can take anywhere from 8 to 12 months, sometimes faster, sometimes longer. And then that case is sent to the National Visa Center, which for our purposes is really, it's a website where the applicant will need to upload some supporting documents and fill out and submit the immigrant visa application. And then once that is prepared and submitted and accepted, the National Visa Center will send it to the embassy. And from there, it's really in the embassy's hands because it's based on their capacity, availability of appointments. And when an appointment is scheduled or an interview is scheduled, um, the applicant will have to to complete a medical exam, typically, attend the interview on their own, and then receive that immigrant visa in their passport. Once they enter the US, that's what triggers printing of the person's green card. And that immigrant visa is usually valid for 6 to 12 months. Okay. Some things to consider are that once the application reaches the National Visa Center, the person who's petitioning has to show that they intend to live in the United States. They can show proof of property that they own, a job maybe lined up in the States, their family. And this is, I tend to see this come up where the couple's actually living abroad first. They're, they want to be together, understandably, and so they're living abroad. So the petitioner has to prove, that they have domicile in the United States, like if they've previously held, they were registered to vote or they have a job offer or something like that. And regarding the income requirements, by the time we get to the National Visa Center stage, the petitioner has to, again, maybe show that they have a job lined up, that or that their foreign income will continue, um, or that they have a joint sponsor. So again, that's that third person who could be a U.S. citizen or a green card holder. It could be a relative or a friend of yours that is willing to provide their last 3 years of tax returns and proof of their immigration status. And then once the beneficiary gets their green card, that person will need to spend most of their time physically present in the United States, which Natalia had already mentioned. Other things to consider is that while the I-130 is being processed, so that's like the big part one of this visa process. I think it's important to know that the I-130 is really just establishing that you are a couple. It's not asking to change the immigrant's status yet. So theoretically, if the person has a tourist visa or has ESTA, they may be able to travel here during that time to visit. They definitely, will still want to comply with the terms of their visa or their ESTA, but they should theoretically have that flexibility to come and go. However, once we're in the big part two, the immigrant visa stage, the beneficiary must be prepared to wait abroad. It's at the immigrant visa stage that we're now saying that the person wants to live here permanently. So cat's out of the bag. They're showing immigrant intent, so there's no more traveling with a tourist visa or some temporary visa. The physical green card will be issued shortly after the person's entry with that immigrant visa. The government fees associated with this whole process are laid out here. It's 675 for the family petition, total of 445 for the immigrant visa fees, and then I think this should say 220 for the immigrant fee, which you pay before you come into the States. If we do provide this PowerPoint, we'll have it corrected, but we'll definitely be providing the webinar recording. Okay. The second way to go about the marriage-based option is green card. So that's when the U.S. citizen or green card holding spouse um, is sponsoring their partner who is physically inside the United States. So it's very similar. It's like the I-130 immigrant visa process, but the whole green card application happens inside, and it's the same end goal, again, to live and work permanently in the US. So this timeline is a little bit different. Parts one and two, the family petition and the green card application, may be filed at the same time. It will kind of depend. If you're considered what's called an immediate relative, um, where the petitioner is a US citizen, you may be able to do this all at the same time. If the petitioner is a green card holder themselves, it just depends. It depends on visa availability. But the case is filed, you get receipts from the USCIS as usual. If you use an attorney, which I recommend that you do, your attorney and you will get copies of all the same documents. You'll go to that fingerprinting appointment and work and travel permits hopefully come very soon. So right now, for me, I'm in my cases, I'm seeing work permits come pretty quickly. I would say around like 2 to 3 months. It really is that travel permit that's very unpredictable. Some clients get it at the same time as a work permit, and some don't get it at all. They just get their green cards, maybe more quickly, maybe not. So there is that uncertainty about when's the next time that you can visit home or leave the States. And then again, green card interviews, I think, are expected in this administration. During Trump's first term, everyone got interviewed, not just family, but employment-based green card applicants as well. I am still seeing interviews being waived at this point, but we are prepared for that to change. And I would just note that this was standard practice prior to the Biden administration. You would expect that, couples would get interviewed. So attorneys are prepared to prepare you for what to expect and attend with you if that's their recommendation. And then green card should arrive within 1 to 2 months, usually faster. Okay. Some things to consider are that the beneficiary has to stay in the US while the green card case is going, unless they have um, the advanced parole. And we'll come back to that. And then unauthorized work and unlawful presence or like overstaying a visa may be forgiven if you're married to US citizen. And then that doesn't mean you don't talk about it. You still have to disclose immigration violations, but they may not count against you. And then others may need to maintain some other status to continue working while their case is pending. So I mentioned earlier, some people can file this whole package um, at the same time. Others, like the type of applicant that comes to mind is maybe someone who was on H-1B or some other non-immigrant status that so that they could continue working. And without the work permit, they may need to maintain that. And speaking of H-1B holders, again, there's no travel outside the US without that advanced parole or the green card, unless you are fortunate enough to have an H-1B or L visa. These statuses are unique. They're what we call dual intent. So they're non-immigrant, but they allow you to also pursue immigrant, um, immigrant intent. So you could have an H-1B visa as long as it's valid and your H-1B is approved. You could potentially travel on that visa. But you'll also, of course, want to confirm with your attorney. And then I alluded to this earlier, green card holders, once they receive that green card, are required to maintain their residence in the United States. I see this come up with a lot of like older couples that maybe have retired and want to spend a lot of time abroad. Or just people who like they have other properties, they have other commitments in other countries, and they like to spend their time like in and out of the States. This can be an issue for a couple of reasons. I mean, you don't want to compromise the green card that took you so long to get, but also later on, if you do want to apply for US citizenship, there are residence and physical presence requirements. And if you don't have enough of those days, then you may not qualify for citizenship. And the fees associated here are 3,005. Back in April, the government increased a lot of their filing fees and also kind of changed the structure. So it's almost like they charge like a la carte for all the different items in your green card package, the petition, the green card application, work permit, and travel card. So let's say you don't require a work permit or a travel card, this price could go down because the fees wouldn't apply. Okay, this is um, the same list that was mentioned during the K1 presentation about how to prove a bona fide marriage. And as Natalia mentioned, we can be creative about the types of things that we show. Social media thrives today, and so um, you know, if there are photos, screenshots that are helpful in showing that you are a couple, we welcome that as long as they're like PG and easy for the officer to like you know, they easily convey that you are together. Um, Maybe that you attend events together where like family and friends comment, what a cute couple you are. Just in general, when we're talking about this bona fide marriage requirement, it is um, a holistic analysis. Like they're looking at the full picture. There isn't, I would say there's not one item that is a absolute game changer here, except for a marriage certificate. Um, and couples have no one's life looks the same. So some couples, they have the house and the car and all the policy joint policies. Some couples have lived with their in-laws and they don't have those the same like utility bills and residential leases. So we would encourage like you to really think about what documents you can show. Let's say you like adopted a pet together, you have a Costco membership, a gym membership, you're listed as your partner's emergency contact person. So we can definitely, help you think of ways to prove that the relationship that you do have is real. Again, photographs. Officers love photographs. The more you can show, the better. I will say we usually tell clients to organize them as best you can, give some context for who's there, what's happening. I don't love a ton of selfies because you can't always understand what's going on or where you are. Um, Natalia mentioned, proof of the proposal and wedding. As you're booking vendors, save all of those agreements. You're booking makeup, photos. You booked a restaurant for the dinner. And I would just encourage couples who maybe think, we don't have a lot of that. We're having a civil ceremony. We're not having a big wedding. That's still fine. I mean, during the pandemic, most couples were having a civil ceremony and maybe a larger reception to follow. Um, that's okay. Whatever you can show from that day of how you celebrated, I think is will be significant. Okay, this is the same kind of list of red flags. I want to go back to one of these, the no shared residence. So almost always, I mean, if a couple is not living together, that couple will be interviewed. But there, for whatever reason, Natalia and I have gotten a lot of complicated marriage cases over the years, and there are reasons why people don't live together. There's case law about essentially saying that not all marriages look the same. Just some examples that come to mind are like if one of the spouses is completing their education or working in another state, or maybe there's kids and stepkids involved, and it's like a decision that was made together that, for the interests of the kids to not combine households yet. It really depends. And if there's a reasonable explanation, we just have to be able to provide that explanation. Okay. Financial sponsorship, again, the petitioner has to present their last 3 years of tax returns. And just to give you some idea, if you're thinking like, what's the magic number? It depends on how many people are in the household. If it's just you two, petitioner has to earn something like in the $25,000 range. It's modest, but it's not nothing. So you do have to look closely at what that number is for you. Oh, one thing I wanted to mention here as well is that sometimes people maybe they aren't working right now or they haven't worked in the last couple of years and they have assets. They have investments, they have money in the bank, whatever it is. The the required forms, the affidavit of support, allow you to point to assets to make up for the lack of income. However, I have found it's almost as if like a robot or something is reading that affidavit of support. And if they don't see the number that they like under the total income, they send a request for evidence. And maybe you need to fight a little bit about proving that these assets are the right amount to kind of prevent any delays. I prefer that we use a joint sponsor. So if you have that third person who's willing to help out, um, that's preferred. And just to kind of mention what that person is signing up for, both the petitioner and or the joint sponsor, if that's what you're using, they are signing a contract that is obligating them to the foreign national so that if in the event the immigrant uses means tested benefits, then the government can come after the joint sponsor for or the petitioner for those funds. That obligation lasts through either the person becoming a citizen, working 40 credits, which is something like 10 years, if the person leaves the United States permanently, or if the person passes away. The obligation does not end if the couple gets divorced. So do keep that in mind. Okay. The interview process looks a little different depending on whether you went the visa route or the green card route. So with the immigrant visa, the applicant is going to go to their consulate and they're going there alone. So they will ask questions about, to verify identity. They'll ask questions about the couple's history, um, and the national security questions that come up on the immigrant visa application. But again, they're attending that on their own. Whereas in the green card context, if you're here in the States, you and your spouse get to go together. They're still gonna verify your identity, ask you questions, but they're asking you both, and you have the opportunity to tell your story together. Um, as Natalia mentioned, you'll take an oath to promise that you're telling the truth. You'll offer up any additional supporting documents because at the time that you filed with what you had. But say it's been a year since you filed. Now you have a year's worth of documents that just didn't exist before. Maybe you have a child now, maybe you guys bought a house. So there could be all these new things that you can present as additional proof, and you should. The officer will go through your case to confirm that all the information is accurate. If there were any typos or any changes, like to where you work or where you live, that should um, be reviewed there. And then again, they'll go over your story. So typically, the types of questions tend to be the same, like how did you meet? And how did your relationship develop? How did you become exclusive? How did you come to the decision to get married? Was it a surprise proposal? Was it a discussion? Who was at the wedding? How did you celebrate? And what are your plans for the future? In some rare instances, the couple can be separated and interviewed on their own, which can be very intimidating. And the depth of those questions is different. They will want to know really specific things about how you live and interact with each other. For example, I've had an interview like this where they asked, do you have a tub or a shower? How many bedrooms and bathrooms? Is the TV mounted or is it on a table? Is there any art on the walls? What shape is it? Like very, very specific, to so that the officer can feel confident that the relationship is real and the couple really is living together. Okay. Um, I'm going to go to the Q&A and see if any questions have come up. Yeah, someone was asking for these slides. We generally don't provide these, but we will provide the recording after we finish. Um, I'll give you guys some time to add your questions. I know we went through a lot of information. I see a raised hand, but please put your question into the Q&A. And Natalia, if you have any other things to add too, please jump in. It
While
can,
we're
oh,
working on the questions, sorry,
go
Catherine.
ahead.
Uh, just wanted to let you know that we are present on the social media. So if you are on TikTok, you can find us there. Yeah, we are also on Instagram. We're pretty active there. So we do stories and we do posts. We do some live sessions in there as well. We are on Facebook, LinkedIn, and YouTube, as well as Blue Sky. So we are almost everywhere. If you'd like to follow us, we'll be happy to have you as a follower, and we'll keep you updated on the immigration news and policy changes.
Okay. Natalia, if you could answer this first one, how much time do we have to be married to apply for the marriage-based green card? Like, do you have to
You
be
can
married for a minimum amount of time?
you can file the same day, literally, once you get your license or whatever it's called in the country where you got married. That's when you can file the case.
Yeah, there's no minimum amount of time, but maybe where it might be relevant is again, the officer's looking at the whole picture. So maybe a scenario where they might not love that is if like foreign nationals um status expires on Monday, you get married on Tuesday, you apply for the green card on Wednesday. Like that timeline doesn't look great, but they're looking at the full picture. But there's nothing in the law that says you have to be married for a certain amount of time before applying.
Yeah, and you can definitely prep the case before you get married, so that's also fine. As long as you don't submit any paperwork before you got married, that's totally fine. You can even pre-draft forms that you will be submitting and list all the evidence. And then once you get married, you just, date the forms and file them with the USCIS. And again, if you have a reasonable explanation behind, your decisions, the USCIS officers are humans, and as long as you can explain yourself, there is a good chance that they will understand your position.
Yeah, I think it's important to note that when the officers are they're looking for fraud, right? Their nose is always looking for that. And fraud means that immigration reasons are the only reasons that you got married. That's why you entered into the marriage. That's not to say immigration can't be part of your reasoning. It just can't be the only reason. Like, but if this was the next natural step for the couple, again, they're looking at the full picture.
And I wanted to add, there are certain exceptions in this process, like if a person, for example, the foreign national is in removal proceedings, sometimes depending on the manner of entry into the US, sometimes you will be required to reopen the removal proceedings in immigration court, set aside that removal order, and then proceed with the filing. Otherwise, the USCIS will not be able to complete certain filings, but that mostly concerns not the Form I-130, which is just the petition to prove that you are a family. That mostly concerns Form I-485. That's when you are applying for a green card. But that's very, very unique situation, I would say.
Yeah, another unique one might be like if the person is in removal proceedings already and then they get married during that time. I mean, you have to meet a pretty high standard for proving that the marriage is bona fide.
There would be also a requirement to submit a statement that is considered to be a waiver of a certain requirement in the Immigration and Nationality Act with the Form I-485 if you married in removal proceedings.
And then another question we have is if you are on a non-immigrant visa and get married while on it in the US, which path you described would be the one? Well, generally speaking, if you're on an non-immigrant visa and you're here, my first question is your spouse a US citizen or are they a green card holder? And what type of non-immigrant visa are we talking about? Because if you came in as a tourist and your spouse is a US citizen, you may be able to just go the marriage-based green card route. if your spouse is a green card holder still, then okay, they're a US citizen, so yeah, you may be able to just apply for the green card here. But what type of non-immigrant visa do you have? You don't have to say it in the comments. I'll just say generally, like, what I'm thinking of is, are you on like a J exchange? Are you subject to a home residency requirement? Which means, do you have to go home first before applying for another type of visa? Um, if so, how do we waive that requirement? So it depends on those two things. What type of visa do you have, and what status does your spouse have? Something that we come across a lot in our practice is ESTA holders traveling. Um, you guys are special folks because you don't need a visa to come in, but that also means that what you do in those 90 days that you're here is really, really important. Um, so are, if you get married, apply for a green card during that initial period, the government can assume that you misrepresented your intentions when you came in. And if your case is denied on those grounds, like on those specific grounds, you could be, I mean, you would just have to leave and there's no recourse for that. Obviously plans change, life happens, your plans can pivot, but generally speaking, that's a very like strict rule for those on visa waiver.
Catherine, would you like to also talk about the 90-day rule?
Sure, or if you want to cover it.
Sure. Uh, so if someone comes to the US on a non-immigrant visa, and a non-immigrant visa, a good example would be a B visa or an O1 visa that was mentioned in the comment. Um, an H-1B visa is a dual intent visa, so it's not a non-immigrant visa specifically, or L1 is not that kind of a visa. But if you have a non-immigrant visa and you came to the US, marry in the US, and you would like to file for an adjustment of status, keep in mind that there is a 90-day rule that the Trump's administration loved um, during the first term. I'm sure during the second term, they will refer to it as well. So the rule is basically a Department of State's rule. It's not the Department of Homeland Security's rule, but the Department of Homeland Security may apply it as well. If you get married within the first 90 days of your arrival in the US on a non-immigrant visa or an ESTA, and you file for an adjustment of status and settle down in the US, just kind of showing an intent to live here within the first 90 days, then the USCIS may accuse you of fraud and misrepresentation related to your intent at the time when you entered the US. So our advice would be if you're here on the non-immigrant visa, just count the days. Try not to file your adjustment of status case form I-485 within the first 90 days, but you can get married within the first 90 days. That's totally fine.
That person didn't say this in their question, but I'm almost certain like people are thinking it. What if you came in without status? What if you entered through the border and now you're married to a US citizen or a green card holder? Your process will look like this, but different. There's like a big thing that needs to happen in between called a hardship waiver, that may require you to leave the United States temporarily. Or maybe you're a DACA recipient and you may or may not have entered with a visa, or you may or may not have obtained advanced parole and traveled since receiving DACA. That can all impact, how your process looks. And if, I feel like the bulk of our cases actually like fall within this questions, this like, what do I do? Period, section of the presentation, because every kind of change in your fact pattern matters. Um, but that's not to say there aren't options for you to adjust status or to get a green card eventually, but it may take a while and it may be more expensive and it may require a lot more work by you and your attorney. So you will definitely want to make sure that you are consulting with an attorney that practices family-based immigration regularly. So I think we will end there. Again, feel free to reach out to us on any of these platforms or to schedule a consultation to talk about your specific situation. Thank you so much for spending the time with us. You have 2 days until Valentine's Day, 2 days to talk about all of this. But again, we're here if you need anything, and thank you so much again.
Thank you.